Okay, this clip is supposed to give a synopsis on some of the arguments surrounding the right to trial by jury. The right to trial by jury has come under attack in recent years. Lord Justice Auld called it into question. The Criminal Justice Act 2003 provides for the right to remove the right to trial by jury in cases on indictment in certain fairly specific circumstances. In Australia, there's been arguments about interfering with the right to trial by jury. In the Republic of Ireland, the Special Criminal Court, which is a non-jury court, continues to function. And of course, in the US, we have the military tribunals associated with the detentions at Guantanamo Bay. So the right to trial by jury is under challenge, shall we say. Now, since the 1950s and beyond, the focus of the legal system in common law jurisdictions has been on the importance of the right to trial by jury. And indeed, Sir Patrick Devlin, later Lord Devlin, argued that the first thing that any would-be tyrant in Whitehall would do, he said, would be to abolish the right to trial by jury. And that ties in with the long kind of philosophy which sees the jury as being a bulwark of liberty and a safety system against any form of tyrannical power. Alexis de Tocqueville, the French philosopher and civil servant, when travelling around America, commented that the jury was the most democratic of institutions because it provided that those who were involved in the process of being governed, that the people got to have a say in how the law was applied, not just in selecting those who make the law, but actually in having some say in how the law is applied, and he saw that as being hugely important. So over the past 100 to 200 years, the right to trial by jury has been seen as being of great significance. Prior to that, however, the history of trial by jury is a little bit more patchy. The early juries, introduced under the reign of Henry II, were chosen specifically because they had some local expertise about the case, and that was why they were employed, for this special local knowledge. Later on, the jury became, as we know it today, that you have to be an entirely independent and impartial jury. So we have this kind of when we say that the jury is the lamp that shows that freedom lives, the question is, well, which jury? What jury is the lamp that shows that freedom lives? So these are kind of questions which arise from time to time. The second thing, which I argue quite strongly in my book, The History and Development of the Special Criminal Court, is that although the right to trial by jury is one means of guaranteeing a fair trial, it is not the only means of guaranteeing a fair trial. And the primary right is the right to a fair trial. So if there are circumstances in which the right to trial by jury is incapable of providing a fair trial, then I would argue it is legitimate to interfere with the right to trial by jury. So in what circumstances might the right to trial by jury be incapable of delivering a fair trial? Well, when we talk about a fair trial, the European Court of Human Rights has said that the jury must be impartial and unbiased, just like the court must be impartial and unbiased, the tribunal of fact and law, so the jury must be as well. And in that context, in Sander versus the UK and in Remley versus France, they argued that the jury had to be impartial and unbiased, and if there was a suggestion of bias on behalf of a jury, then that was a serious matter, and that would be an abuse of the defendant's rights. So if there is a problem of jury bias, then we might consider removing the jury in that case, or in those cases. Other examples where there might be a particular problem, and this involves considering what a miscarriage of justice is. If we consider that a miscarriage of justice is not only convicting an innocent person, but is in fact allowing a guilty person to go unpunished, then if there is a risk that a jury is going to be intimidated and therefore find against the evidence, be unwilling to convict someone who is patently guilty, then that would also be a miscarriage of justice. And in those circumstances, if there was a risk of jury intimidation from a terrorist organisation or an organised crime gang, then it might be legitimate to remove the right to trial by jury in those circumstances. And indeed, that's been argued in the Republic of Ireland in relation to its Special Criminal Court. So what I would suggest is that when you approach the topic of trial by jury, a lot of what has been written about it has been written from the assumption that trial by jury is positive and needs to be defended. And that's not a bad place to start, but you need to have an open mind and consider those circumstances, limited and all as they might be, in which it is acceptable to interfere with that famous right. And if we adopt Conor Gearty's argument, about rebalancing civil liberties, that we need to refocus on the core civil liberties, then the suggestion would be that instead of focusing on the right to trial by jury, we should emphasise the right to a fair trial. And as long as we can secure a fair trial, it doesn't really matter whether we're employing a jury or not. Now, that's not to say that we should abolish the jury altogether, because the jury brings with it other advantages. As de Tocqueville said, it educates people about their function within society, it involves people. So it has these kind of, and symbolically it's important. But it's just to say that in circumstances where we believe that there is a threat to justice in employing a jury, then we should consider doing something else. And that basically is my argument. Take care.